StudyIQ IAS, अब तैयारी हुई अफोर्डेबल।
Good afternoon, everyone. I hope this message finds you fit and fine. I hope my voice is fine. Everything is set at your end. Let's start. So today we need to discuss amendment to Indian Constitution. कई बार मन में सवाल आता होगा कि इस प्रिपरेशन को शुरू तो कर दिया है, मज़ा भी आ रहा है, तभी आप इस वीडियो में हैं, सीखने को तो मिल रहा है, लेकिन क्या उतना पढ़ा जा रहा है जितना इस एग्जाम को क्लियर करने के लिए ज़रूरी है? क्योंकि अल्टीमेट ऑब्जेक्टिव तो क्या है? योर नेम इन मेरिट लिस्ट। तो देखिए, कंटेंट तो सेम है, लेकिन कंटेंट को यूज़ करने की हमें स्किल डेवलप करनी है। कैसे होगी वो स्किल डेवलप? पहले तो भाई टाइम से हर एक सब्जेक्ट का कंटेंट तैयार होना चाहिए। अगर आप वो कर रहे हैं ठीक है, लेकिन इफ़ यू वांट टू टेक हेल्प तो आप StudyIQ की हेल्प ले सकते हैं। जो StudyIQ का P2I प्रोग्राम है, आप StudyIQ ऐप या वेबसाइट पर देख सकते हैं। P2I मतलब प्रीलिम्स से लेकर इंटरव्यू तक का एक प्रोग्राम। तो ये एक प्रोग्राम के अंदर 4 फेजेस हैं। तो उस 4 फेजेस के थ्रू पहले ही फेज में आपका कंप्लीट सिलेबस हो जाएगा। तो इट इज लाइक द बेसिक थिंग, ये तो करना ही है। इसके बाद आता है कि हमें स्किल्स डेवलप करनी है, यानी कि उस कंटेंट का प्रीलिम्स में इस्तेमाल हो सके, उस कंटेंट का मेंस में इस्तेमाल हो सके, यानी कि आंसर राइटिंग। फिर हमें असेसमेंट चाहिए बीच बीच में, जिससे कि हमें कमियां पता लगती रहें। तो इसके लिए भी P2I में आपको प्रीलिम्स मेंस दोनों की टेस्ट सीरीज दी जा रही है। वीकेंड पर भी टेस्ट होते हैं, प्लस डेली मेंस आंसर राइटिंग होती है। तो आपको नहीं लगता अगर इतना कोई मेहनत आपके साथ कर ले तो आप करना तो चाहते हैं, बट एक पाथवे नहीं है, तो P2I प्रोग्राम वो पाथवे आपके लिए साबित हो सकता है। तो टेक हेल्प ऑफ दिस। फिर आपके मन में कभी कभी जो डाउट आता है उसको ढूंढने के लिए आपका काफी समय जाया हो जाता है। जाया इसलिए कह रहा हूं क्योंकि हो सकता है उस डाउट को ढूंढने के लिए आपने 1 घंटा लगा दिया, क्योंकि उससे एसोसिएटेड काफी सारी चीजें नई नई पता लगती चली गई आपको। ऐसे में इस टाइम को रिड्यूस कर सकते हैं आप। एग्जाम ओरिएंटेड क्या उस डाउट से रिलेटेड नॉलेज आपको चाहिए, वो आपको एक पर्सनल मेंटोर बता सकता है। तो इस कोर्स में फैकल्टीज तो आपके साथ हैं ही, इस पूरी जर्नी में आपको पर्सनल मेंटोर दिया जा रहा है, आप उसकी हेल्प लीजिए। आप कॉल व्हाट्सएप पर कभी भी उनके साथ कनेक्ट हो सकते हैं। उनका नंबर आपको इस कोर्स में स्पेसिफिकली आपको अलॉट होगा। तो अल्टीमेटली आपका टाइम बचेगा, कॉन्फिडेंस आएगा प्रिपरेशन में। फिर जैसे आप प्रीलिम्स क्लियर कर लेते हैं तो उसके बाद मेंस रेजिडेंशियल प्रोग्राम, ये इसका सेकंड फेज मतलब थर्ड फेज कहिए, क्योंकि पहले फेज में फाउंडेशन है, फिर सक्सेस इन प्रीलिम्स है, फिर MRP मेंस रेजिडेंशियल प्रोग्राम। फिर उसके लिए आप दिल्ली बुला लिया जाता है आपको। यहाँ पर आप मतलब जो फूडिंग लॉजिंग एवरीथिंग इज टेकन केयर बाय StudyIQ। और उसके बाद फिर रिगरस प्रिपरेशन होती है आपकी मेंस के हिसाब से, यानी कि हर एक जो आपका पेपर है, GS है, लैंग्वेज है, essay है, हर एक की तैयारी यहीं पर हम आपको अपने सामने कराते हैं। उसके बाद जैसे आप मेंस क्लियर करते हैं तो इंटरव्यू गाइडेंस प्रोग्राम, वहाँ पर आपके कोहोर्ट्स बनते हैं, जिसमें डिस्कशन के थ्रू जो आपके अदर एस्पिरेंट्स हैं, जो आपके साथ इंटरव्यू देने वाले हैं, तो आप अपनी स्किल्स को पॉलिश करते हैं। साथ में ब्यूरोक्रेट्स, फॉर्मर टॉपर्स, ये सब फैकल्टीज आपको मिलकर गाइड करते हैं। फाइनली व्हेन यू आर थ्रू इनटू द मेरिट लिस्ट, देन फिर आपको लगता है कि हाँ, इट वाज ऑल वर्थ इट। मिलते हैं आपसे क्लासेस में, ख्याल रखिए। जय हिंद। सो व्हेन आई से अमेंडमेंट, so it means 3 words. Whether you want to add something in Indian Constitution, it means plus. Whether you want to repeal something, REPEAL, means you want to subtract something from Indian Constitution, right? Other is you want to alter the language. Okay, this can also be done. So in these 3 ways you can amend Constitution of India. But why amendment procedures were added? Why there is need of amendment? Can there be a good constitution which is not having any scope of amendment? So on this point, Chairman of Drafting Committee, Mr. B.R. Ambedkar, made a statement. He said, a constitution which is rigid in feature, it means where there is negligible scope of amendment, cannot be considered a good constitution, because with the changing time there will be new aspirations in the people. People will need new kind of laws, people will need new kind of laws backed by some provisions which are mentioned in Indian Constitution. So they want to add something in Indian Constitution. They want to increase the sanctity of some laws. So for this purpose, amendment was needed, right? So there is another famous scholar, Mr. K.C. Vere. So he said that Indian Constitution's amendment scheme provides a balance between rigidity and flexibility. So the statement is made by K.C. Vere. Another legal luminary, Mr. Granville Austin. Why I am talking about them? Because in a mains question, you have to use these statements, right? It's not about the way to amend Indian Constitution. That is what you need to express solely, right? So Granville Austin said, the diversity of amendment procedures in Indian Constitution is unique and needful. Amendability, diversity. So it means multiple ways to amend Indian Constitution. Now I find lot of trap questions, scope of lot of trap questions from simple provision of amendment of Indian Constitution. That is why we are interacting in this session. So you can find now procedure for amendment. Now the first statement says that an amendment to the Constitution of India, and after reading the statement, I'm going to ask two questions which I find are important. An amendment of the Constitution bill can be initiated either House of Parliament. It means Lok Sabha or Rajya Sabha. Means proposal to amend Indian Constitution. This bill can be brought in Lok Sabha or Rajya Sabha and not in the state legislature. Means a bill for amending the Indian Constitution cannot be brought in state legislature. Now, after reading the statement, now you have to answer one question of mine. Statement is, state legislatures in India have no role in amendment procedure of Indian Constitution. Now tell me, the statement is true or false. You have read the statement and now I'm asking, a state legislature has no role in amendment procedure of Indian Constitution. Yes or no? Come on. Yes or no? Because these provisions sometimes students misjudge, misinterpret, miss on the intricacy in these provisions. Some students might say, answer is yes. It is quite visible from this. A state legislature are not going to have any role in amendment procedure of Indian Constitution. My friends, answer is no. Answer is no. Because the statement is just telling you bill for amendment of Indian Constitution cannot be started in state legislature. But there are ways where you will need a state legislature. So what I told you, this is bill. We are saying it constitutional amendment bill. This bill can be initiated in Lok Sabha or Rajya Sabha, okay, and not in a state legislature, okay, not in, but the word is initiated. That needs to be highlighted. And there is the detail, the beauty of this provision is here. Now, consider point that our parliament wants to amend some federal feature. It means our parliament through a constitution amendment bill wants to change the power relation between center and state. For example, amending the Schedule 7 of Indian Constitution, which talks about union list, state list, concurrent list. Now, in this case, is there no role of state legislature? My friends, answer is yes, there is a role of state legislature. What is the role? In this case, the bill which we are talking about, it means constitutional amendment bill, can be initiated from Lok Sabha and Rajya Sabha. It means the earlier understanding of ours is solid, okay? But in this case, the bill, after this process is done, It means if this bill is first presented in Lok Sabha, then it will be transferred to Rajya Sabha. After this bill needs to be presented in state legislatures, because at least 50% of state legislature need to give assent, confirmation by simple majority that yes, we are agreeing to this constitutional amendment bill. Then this bill is presented to Honorable President. When President signs this bill, for example, Shashank Tyagi, you will never know what happens in future. Then this bill will convert into CAA, means Constitutional Amendment Act. Okay, so it means role to hai, there is role, right? And the earlier statement was saying there is no role. And role in which case? For example, amendment of federal features. There are other cases as well. We are going to talk about them within this class. Okay, so I hope now you are not going to make this mistake. Be clear about the details. Role. Okay, initiation of bill will not happen. Initiation of constitution amendment bill will not happen in state legislature, but role is there in case of federal features. Okay, now another statement, another beauty of this provision. No resolution which is related to amendment of Indian Constitution cannot be initiated in state legislatures. Now tell me, the statement is true or false? Come on. And I want all of you to have Lakshmikant in front of you. You can do the cheating work. Scroll the pages and then you can answer. Yes. So should I repeat my statement? And some of you might be wondering, if such statements are so much important and there can be a scope of you can say doubt or mistake in exam, then why I'm not putting them on this PPT? The reason is I want you to note them down. Okay, so the chances of mistake are negligible, 0. Okay, so my another statement is, I said a state legislature cannot initiate any resolution related to constitution amendment. Okay, I asked the statement is true or false. यहाँ पर the point is cannot. Answer is no. It means there is a scope. Yes, it can be done. In one case only. There's a one case in which such resolution can be passed. Now, first of all, what is the meaning of this word resolution? And earlier we were saying no bill can be initiated related to constitutional amendment bill in state legislature. Now we are saying resolution can be initiated. So what is the difference? Purpose of resolution is to gather the consensus of the House that we agree that such thing should be done. Should be done. Okay? But when we talk about bill related to constitution amendment, it means as this bill is going to be initiated, as this bill is going to be passed and going, get into the procedure to be passed from Parliament, then it will be converted into an act. Means action will be done. Okay, but in resolution should be done. Okay, now we have resolved. Now the point is, which case we are talking about? In case of Legislative Council, for example, if a state at state legislature is only having state legislative assembly, whom we call Vidhan Sabha, but they also want Vidhan Parishad, it means state legislative council. So in this case, this state legislature can brought up a provision, resolution, that let's discuss this, let's find that whether House agrees on this fact that we need to have a second house at the level of state, which is Legislative Council. So they can actually do this. But beyond that, they cannot do anything. Means it is the prerogative of Parliament to initiate such bill and to get this done. that to provide a particular state legislative council, but resolution can be initiated. Okay, so I hope now you are clear about this. Yes or no? If you are clear, mention clear in comments. Right? Now, let's talk about second point. Just read what second point is saying. The bill can be introduced either by a minister or a private member. Please remember, these kind of details are used in statements by UPSC. It means many students think that since we are talking about constitution amendment, this is such an important step, the power to actually bring this bill must be with only minister, but such is not the case. This can be done by private member also. Who is private member? Private member is not, that's people like you and me who are not part of parliament, and we can say, oh, we have read private member can introduce this bill, so we have brought constitution amendment bill. No, we are not considered as private member in this language. Private member means any member of house who is not a minister. So it means if BJP is ruling the, you can say Lok Sabha, majority parties in Lok Sabha is BJP. So it may be possible that a member of BJP who is not, means member of parliament and who belongs to BJP, who is not a minister, but he can propose this particular constitution amendment bill. Okay, in that case, this bill will be considered, oh, this bill is proposed by a private member. And similarly, this bill can also be proposed by opposition member who are not minister. That's why they are in opposition. For example, any leader, Congress leader, any party, member of say Lok Sabha, or in case of Rajya Sabha, they can also propose such a bill. Okay, does not require prior permission of president. Okay, for example, as we are going to move into Parliament chapter, there you are going to understand about money bill. So in that case, money bill is introduced with prior permission of president. Prior permission means president has actually gone through the bill. Okay, actually reality is there are bureaucrats in the president house also, so they go through the bill and they give a short note to the president, sir, this bill is talking about this, and all the legalities have been checked, and yes, you can actually give the recommendation to present this bill in Lok Sabha. So for example, budget, right? But in case of constitution amendment bill, no such prior permission of president is needed. Okay, now what is the difference between public bill and private bill? One difference is clear: presented by minister, presented by any other member of house who is not a minister. But what are the other areas? For example, it reflects the policies of the government. It means ruling party. Okay, it reflects the stand of opposition party, because many times there are opposition members who want to propose a bill. Okay, and so that they can make voice their concern that this bill is important. But the point is, which bill do you think is likely to pass? Obvious answer is public bill, because it is presented by minister of the party is definitely having majority in the house, and that's why they are in power. But in case of this, lesser chance to be approved by parliament, because this party may not be having majority in the house, is not having majority in the house. I'm using the word may not. The reason is because there can be a member, private member belonging to the BJP also. Okay, now these intricacies, multiple interpretations, we should be having keen eye. Okay, because UPSC wants to check your understanding on these details, because officer has this quality. This is part of OLQ, that you have attention to the details. Its rejection by the house amounts to expression. For example, if honorable minister, say Ministry of Home, so they have presented a bill and this bill could not pass Lok Sabha. What does it mean? It means they do not have majority in the Lok Sabha. Otherwise, how can a bill presented by a minister can actually cannot pass? This is not possible, right? So this amounts to resignation of the concerned party, concerned ruling government also. Okay, but in case of private member bill, there is no such case. Its introduction in the house requires 7 days notice. We are talking about public bill. But when it comes to this, its introduction in the House requires 1 month's notice. So it means, which bill do you think is given priority in legislative process? Obviously, public bill. Okay, because on 7 days notice it can be presented. Please remember these kind of details. UPSC is asking these kind of facts. It is drafted by concerned department in consultation with the law department. Okay, for example, Ministry of Women and Child Development. Okay, they want to bring a bill regarding amendment of Juvenile Justice Act, because it deals with you can say children in conflict with law. It also has proposals for children who need care of law, right? So in that case, this ministry is presenting this bill. So this ministry will consult certain consultants, certain lawyers on panel within the department, but thereafter they're also going to consult legal department, right? So it means this functioning is going on within ministry, within government. But when it comes to private member bill, it's drafting the responsibility of the member concerned. So because it's a private member bill, so you have to do it in your personal capacity. Government support, department support is not available with you. Okay, so these are the details. Now, the bill must be passed in each house by a special majority plus absolute majority. Please remember, we are talking about Constitution Amendment Bill and this amendment procedure as per Article 368. Okay, a special majority means we are talking about 2/3 of present and voting. Okay, those who are members present. For example, if 90 members are present, okay, and they are voting, so special majority will mean 2/3. What is 2/3 of 90? Come on. 60. So 60 will be the special majority. Okay. When it comes to absolute majority, it means we are talking about 50% plus 1 of total strength of house. Total strength. What does it mean? It means if 100 is the total strength, so it means absolute majority will mean 50 plus. Okay. So both the conditions need to be true, then only this particular process will be considered ki haan, this particular process is done. Each house must pass the bill separately. Now, what happened if Lok Sabha initiated the Constitution Amendment Bill and this bill went to Rajya Sabha, but Rajya Sabha stalled the process. Rajya Sabha is not agreeing to pass it. Okay, and it is not necessary that the party who is having majority in Lok Sabha will have majority in Rajya Sabha, right? There can be a possibility. So in this case, what is going to happen? Dekhiye, this is the difference between ordinary bill and Constitution Amendment Bill. In case of ordinary bill, there can be a process of joint sitting. It means both can sit together, and then there will be a discussion, and then there will be a vote. Now, my friends, tell me, who is having more strength? Who is having more members? Lok Sabha or Rajya Sabha? Lok Sabha. So if they are going to have joint sitting, so who is going to have majority in this joint sitting? Obviously, Lok Sabha is going to dominate this joint sitting. So what does it mean? That by the strength of Lok Sabha will make sure that it will get passed, right? So majority party will have more say here. But in case of Constitution Amendment Bill, can we risk of having joint sitting? Because why Constitution framers did not edit the concept of joint sitting? Because they did not wanted that Constitution amendment should be done on the whims of ruling party. Okay, there should be a discussion, debate, consensus, and through this process, Constitution should be amended. And that is why no provision of joint sitting was added with regard to Constitution amendment. Please remember it. Okay, this is what has been discussed or mentioned here. Okay, now if the bill seeks to amend the federal provisions, what is going to happen then? You need state ratification, right? It must be ratified by the legislature of half of the states by a simple majority. So half of the states by simple majority. Now I'm making a statement from here. and you have to tell me statement is true or false. Okay. If constitution amendment is related to amending federal features, then this bill must be having, ratification. This bill needs ratification of at least 50% states, comma, within the time provided by Parliament. Tell me the statement is true or false. Come on in comments. Should I repeat? In case of amendment of federal features, this bill need to be passed or need to be ratified by at least 50% states, comma, within the time provided by Parliament. So about time, nothing is mentioned here. But in my statement, I have added this twist of time. Now tell me. Answer is no. Many students will fall into this trap when UPSC is going to make this statement, because they have read this line. So the whole line is correct, but the twist of time is wrong, because there is no such mention of Parliament is going to give time to the state legislature that within this time you have to pass it. Okay, so if you are clear about this now, mention clear in comments. After passed by both the houses of Parliament and ratified by state legislatures in case federal features are amended, where necessary, the bill is presented to the President for assent. Okay. Now, here starts the story. Whether it is binding on the President to give assent, or President can reject this bill. Now read the statement. The President must give his assent to the bill. Must word is used. Please remember that. Some of you might be thinking this, how can this happen with the Honorable President? President is having veto power. We have read veto power. But with respect to Constitution Amendment Bill, we are going to discuss the amendment which was done in Article 368, which led to making it mandatory on President to actually give assent to this Constitution Amendment Bill. Now, if such a statement is made, if a bill is having some unconstitutional provisions with regard to amendment of Constitution, and it is passed by Lok Sabha, Rajya Sabha and presented before President, then President must give his assent to the bill. Now tell me the statement would be true or false. He can neither withhold his assent to the bill nor return the bill for reconsideration of the Parliament. Now some of you might be thinking, sir, if the bill itself is having unconstitutional provisions, then why we are using this statement which is mentioned in Article 68 that President must sign the bill? Why? Don't you think it can create constitutional crisis? My friends, you need not to worry about it, because there is Supreme Court sitting here as guardian of Indian Constitution. Okay, so if anything of this, if this, you can say any provision which is considered unconstitutional and President has given his assent, then Supreme Court will use judicial review and declare it null and void. Okay. Now, after the President's assent, the bill becomes an act, that is a Constitutional Amendment Act. So in this case, yahan par we are going to have Constitution declared amended. Okay. Now, with regard to the amending powers of Parliament, Kesavanand Bharati case clearly said that yes, Parliament is having power to amend Indian Constitution subject to basic structure of Indian Constitution, and basic structure is defined by Honorable Supreme Court on case-to-case basis. Now, amendment under this constitution scheme. So there are three processes, or you can say three ways of amending Constitution. So Article 368 is quite clear, but many students who read Lakshmikant for the very first time, or having experience of Indian polity for the first time, they see, okay, there's a dedicated part in Indian Constitution right? 20. And it is talking about amendment to the Indian Constitution. So they actually, fixated on this idea. Okay, when it comes to amendment of Indian Constitution, the process is mentioned only in Article 368. But that is not true. The reason is there are other articles as well which talks, or you can say give you scope for amendment of Indian Constitution. Okay, so it means Constitution can be amended via simple majority also. And just read, amendment fall under 3 categories. So first is affected by simple majority. For example, I hope you remember when we were discussing part 1 of Indian Constitution, there I discussed Article 2, Article 3, Article 4. And there, when I was explaining you Article 4, I explained the whole process also. Process of bifurcation of state. We did the trifurcation of Uttar Pradesh in that video. So Article 4 gives you the scope to amend Indian Constitution with respect to altering the boundary, bifurcation of state. So this can be done by simple majority. Apart from this changes related to state, there are other ways also, means other areas also where this simple majority as a process is used to amend Indian Constitution. And I find that there can be one scope of question asked from this area. UPSC might say that in which of the following cases Constitution cannot be amended by simple majority. I am repeating it. If you have notes, you should note this down and put it in star, because this is an important dimension of question. In which of the following case Constitution cannot be amended by simple majority? And they're going to give you 4 options. Okay, and you have to identify, in which case it is not amended by a simple majority. For that, we need to discuss the list itself. We are going to discuss it, but you should know this is one scope of question. Now, affected by special majority means 2/3. In this case, if you want to amend Indian Constitution and that amendment is not related to changing the federal features, then in that case, this can be done via simple majority. It means 2/3 of present and voting. Along with this, the majority part. Affected by special majority and ratified by states. So, a special majority and ratified by state, this is used when federal features are going to be impacted also. Now, what are the difference between these type of majorities? Simple majority, as I told you, more than 50% of present and voting. Absolute majority, it means more than 50% of total strength of the house. A special majority, so special majority generally 2/3 of the total strength, but this particular case 2/3 of total strength is used only in one case, that is impeachment of president, right? Apart from this, the meaning of special majority also include 2/3 of the present and voting. Okay, so this is the meaning of special majority. Okay, and many students get confused, sir, when it comes to this amendment to Indian Constitution. Earlier you said special majority plus absolute majority, but there I am just talking about what special majority means, what kind of special majority can be used here. Okay, now effective majority, it means more than 50% of effective strength of house. Now, what is the difference between effective strength and total strength? Consider the total strength of house is 100. It means 100 seats are there. Now, let's check the vacant seat. Means it may be possible that some members got disqualified, died, or resigned. Consider this tally is 20, and in those majority. But in this case, when we talk about absolute majority would be 50 plus, because it is more than 50, 50% of the total strength of house. Okay, I hope it is clear now. Now, just attempt this question. Some simple questions are there. Consider it as a rapid fire round. You need not to wait. Just read and attempt in comments. Come on. For formation of new states and alteration of areas, boundaries, names of existing states, a bill needs to be passed by simple majority, special, absolute, effective. Come on, fast. Answer is simple. I've just told you Article 2, 3, 4. For admission or establishment of states, a bill needs to be passed. Come on. Simple, spatial, absolute, effective. This statement is coming from Article 2, and with respect to any changes made in Article 2, procedure is clearly mentioned in Article 3, clearly mentioned in Article 4. It means it is done via simple majority. I've just explained this to you, and I'll also explain this in part 1. Now, another question, a good one. Article 368 itself can be amended by, come on, A, simple majority of parliament and spatial majority of state legislature. So देखिए, those who are thinking that this first option is correct, one case is wrong, another is sarasar wrong. So this is sarasar. Okay. If someone is marking this as correct after going through this session, then that is sin. Paap hai wo. Okay. Now, spatial majority. Why? What is the logic? Logic is Article 368 was also mentioning that if you are amending constitution in such a way that is going to impact federal features, in that case ratification by 50% state is also mandatory. So it may be possible that you want to amend Article 368, amend the power of parliament, amend the process of amendment of Indian constitution in such a way parliament, you want to give more power to parliament. Don't you think it is going to impact the status and role of state as well? Right? So by this logic, now read C and D. Consent of half the state legislature by absolute majority and parliament by simple majority. This is also wrong because you have given too much status. Now you have given too much preference to state, right? A spatial majority of the parliament and consent of half of the state legislature by simple majority. This is correct. Okay. D is answer. Now, what is the time limit within which the state should give their consent to the bill? Which bill we are talking about? We are talking about Constitution Amendment Bill, which is impacting federal features. Okay. In this context, this question has been made. Come on. Answer is no time limit has been prescribed. Okay. Now, I told you one scope of question would be that UPSC will say which of the following case the constitution amendment cannot be done by simple majority or special majority, right? So now you need to read the types or the cases in which a particular amendment procedure is used. For example, election of the president and its manner, a special majority of parliament with consent of state. Now you need not to think that this is just pure cramming. Ratta wala kaam nahi hai. UPSC means this polity is actually, UPSC is going to check whether you have understood the polity or not, understood the essence of polity or not, because it is connected to the essence of polity. For example, election of president. So when you read election chapter, election of president, so who participate in election procedure of parliament, election procedure of president? Elected members of Lok Sabha, Raj Sabha, as well as elected member of state legislature. So if parliament wants to amend the election procedure of president, don't you think there can be a possibility that elected state legislative members' right to participate, right to vote in president election can be taken away? So don't you think it will impact the, you can say, status of state, role of state? So now thinking about this, now think what kind of majority is needed, what kind of procedure of amending this constitution is needed. You need this process, consent of state. 50% states need to ratify this. Okay. Extent of the executive power to the union state. Clearly, we are talking about power between them. Supreme Court and High Court. Distribution of legislative power between union and state. I told you, Schedule 7. Any of the listed in 7 schedule representation of states in parliament means Rajya Sabha, right? Power of parliament to amend the constitution and its procedure. Article 368 itself. So my friends, no question related to this dimension should not be marked wrong by you, because now you have understood the logic behind this provision. Why consent of 50% state is needed in this amendment. Now, simple majority of parliament. Admission or establishment of new state, discussed, Article 2. Formation of new states alteration, discussed, Article 3. Abolition and creation of legislative council in state, discussed. I made a statement from this, right, within the session starting. Second schedule, talking about emoluments, allowances, privileges, so on of president, the governors and speakers and judges, etc. Quorum in parliament. Quorum means minimum number of people which are required so that house will continue or start its proceedings. So these cases are given in simple majority because they are not going to make wide impact on the power dynamics between center and state, as well as they are not going to give major change to the constitutional schemes. These points are considered that they can be done in a swift manner considering the demands of the time. For example, changing the emoluments. Okay, changing the emoluments can be done by simple majority. Please remember it. Salaries and allowances of the members of parliament. This can be done by simple majority. Rules of procedure of parliament, simple majority. Privileges of the parliament and its members and its committees, simple majority. So the points which are directly related to their money, their influence, their privilege, they can be done, the provisions can be amended by simple majority. Okay, you can remember it like this. Now, by special majority of parliament, if you want to amend fundamental rights, if you want to amend DPSPs, any other provision which do not covered in the first and third category, means first category we're talking about, say 50% state need to give ratification, and then simple majority. So apart from that, you need to use a special majority. Okay. Now, criticism of the amendment procedure. It is said that, for example, in US, when there is need of amending the constitution, there is a constitution convention. The idea says, some scholars says, that constitutional amendment is of such importance that there should be a dedicated body for that, who is going to analyze whether such amendment is needed or not. According to some, there should be a separate constitution assembly for amending the constitution. They say, because constitution assembly made the constitution, so we should reconstitute constituent assembly. If we collect so many provisions which need to be amended, and then discussion and this process should continue. Why this power of amendment is given to parliament? So this is a criticism. Okay. This power is vested in parliament and only in few cases in the state legislature. Which case? When amendment is going to impact the prospects for state. Major part of constitution can be amended by parliament alone, as I told you, either by special majority or by simple majority. So this is a criticism, that it says that India's constitution scheme is tilted towards center, unitary feature. Constitution does not prescribe the time frame within which state legislature should ratify or reject the amendment submitted. I asked a question from this particular dimension. Also, it is silent on the issue whether states can withdraw their approval after according the same. If states have given the ratification, can they withdraw? Nothing is told by our constitution in this regard. Okay. There is no provision for holding joint sitting here. Also, I told you what is the reason behind it. In case of joint sitting, the power would be disproportionately tilted towards Lok Sabha because Lok Sabha has more strength, right? That was the logic. But why they criticize on this part? They say if there's a condition that this constitution amendment bill is stuck in Lok Sabha or Rajya Sabha, then there should be a case of joint sitting so that deliberation discussion can happen. And please remember, I'm making a statement, you have to answer. Okay. Statement is, with regard to constitution amendment bill, if Lok Sabha has passed the same and Rajya Sabha has not passed this for 6 months, then this will be considered as a condition of deadlock. Tell me the statement is true or false. And UPSC can also use the statement in a way, as per Indian Constitution, as mentioned in Indian Constitution. If a constitutional amendment bill is passed by Lok Sabha and then presented to Rajya Sabha and it is not being passed by Rajya Sabha for 6 months, then it will amounts to condition of deadlock. Tell me, the statement is true or false? Come on. Answer is false. Because there is no mention of this word deadlock in our Constitution. Even with regard to Constitution Amendment Bill, if this bill is stuck in other house, then this is not considered as a situation of deadlock. Because in our constitutional scheme, with the condition of deadlock as a solution, joint sitting is proposed. But this is not the case when it comes to Constitution Amendment Bill. Please remember these details. UPSC is going to play on these details and you have to mark a shot. Now, the provisions related to amendment procedure are too sketchy. Means too much detail, diversity is there. It could have been made to, a bit simpler. So I hope now you are clear with the procedure to amend Indian Constitution and important dimensions from where questions are expected in your upcoming prelims. So if you have any doubt, you can shoot me a message on Telegram or Twitter. I'll be there for you. And I'm also available in this Telegram group, Shashank Tyagi for you. It means you'll find this PDF uploaded in this group. Okay.
StudyIQ IAS. अब तैयारी हुई अफोर्डेबल.